Hey, yeah, what's poppin', gang? All right, man. It is what? Tuesday? We back. What's good? All right, man. So, I don't think that this is new. I'm not sure, unless it's another instance of subpoena serving. Pause. It sounds weird when I say it like that. But if this is another instance of serving subpoenas, I don't necessarily know if this is new, man. I honestly had a little bit of trouble finding some of these documents. Had a little bit of trouble finding some of these documents, so I was able to find them, but I do believe these are Drake like fan and stan pages, man. So I'm not really here for that information. I'm here for the documents, man. So I love how us reactors and YouTube content creators, man, have kind of turned into LawTube in a sense. I've had several lawyers on the pages that are like, yo, you guys actually make this entertaining. Like, I'm a lawyer and I hate doing this. I hate reading all of this. But the way you guys do it, man, really makes it a bit more interesting. We are not lawyers, fam. Like, I would never even try. I am literally reading word for word and just kind of drawing an opinion. But shout out to the lawyers who aren't in the comments bashing us like y'all don't know what y'all talking about. Y'all literally like, bro, it's all good, man. Y'all reading it. And then some of them do try to provide a little bit of clarity. My lawyers out there, if you guys want to join my Discord, feel free to join my Discord and hit me up with a message. If you guys are able to talk about it behind the scenes and just kind of give us a little bit more understanding from, so it's a little bit more personal. Maybe we can have a conversation where you can kind of break down some of these things. I think that's some of the things that people kind of want to see. I don't know if that's within anybody's scope, but just throwing it out there. All right. So we are back with another video. Make sure you guys hit that like button and subscribe to the channel. You guys can follow me on all my socials right here, man. Literally like less than 200 subs away from 40K. Y'all are absolutely amazing. Thank you guys so much. So I'm going to read this from the OVO docket. Like I said before, I do believe this is like a Drake fan page. They just have the documents, so I'm reading them from there. But like I said, we're not here for any of that other stuff, man. So Drake's legal team has been unable to serve Joshua Delcini, aka Josh Kaplan, with a subpoena. Joshua Delcini was named as a witness who is in possession of relevant documents and information of the violation of New York general business law claim and Drake's amended complaint. The claim centers around deceptive business practices allegedly used by UMG and UMG employees for the promotion of Kendrick Lamar's Not Like Us. As such, Drake's legal team is requesting that the court issue an order for Joshua Delcini to be served with a subpoena by alternative means. So just so we kind of have subpoena means that they got to come to court, but let me see if I can get just like a writ ordering a person to attend court, because I know sometimes people be like, I don't really know what that means. So that's what that means. All right. As such, Drake's legal team is requesting that the court issue an order for Joshua Delcini to be served with a subpoena by alternative means. To support their motion, Drake's attorney has filed a memorandum of law and declaration. Both documents are linked below. Okay. So these are the documents I was referring to. We are going to read these. They're kind of short and one is a little bit longer. So let me go ahead and get into this one. I think I actually opened it up already. My bad. There we go. So everybody can see it over there. All right. Aubrey Graham, plaintiff, UMG Recordings defendant. Memorandum of law in support of plaintiff's motion for leave to serve a Rule 45 subpoena on third party Joshua Delcini, aka Josh Kaplan, by alternative means. Okay, so it seems like they're looking for other ways to serve Joshua Kaplan because they have not been able to get a hold of him. So here's just how it's going to break down. Plaintiff identified Mr. Kaplan as a relevant witness, Drake. Drake has made exhaustive efforts to locate and serve Mr. Kaplan without success. Argument. Service on Mr. Kaplan through traditional methods is impractical. impracticable, service by alternative means is reason to be calculated to ensure that Mr. Kaplan receives actual notice of the subpoena. I guess if you dodge it enough, or you could just say, hey, I never got it. So I guess they're trying to use a different method in order to be able to get a hold of him. All right. Plaintiff Aubrey Drake Graham respectfully submits this memorandum of law in support of his motion for leave to serve a Rule 45 subpoena on the third party Joshua Delsini, aka Josh Kaplan, by alternative means. Background: on January 15, 2025, plaintiff commenced this action against UMG Recordings, Inc., asserting claims for defamation, harassment in the second degree, and violation of New York General Business Law 349, and filed an amended complaint on April 16th alleging the same. ECF numbers 141. Plaintiff alleges inter alia, lawyer, let me know what that means, that UMG published and promoted the defamatory material, which contains statements about plaintiff that are false and defamatory per se, and that it did so with actual malice. Plaintiff further alleges that in publishing and promoting the defamatory material, UMG engaged in deceptive acts and practices by covertly, financially incentivizing third parties to play, stream, and promote the recordings, and then by making materially false and misleading representations and omissions to consumers. Plaintiff identified Mr. Kaplan as a relevant witness. Plaintiff has identified Josh Kaplan as a witness likely to have information relevant to plaintiff's deceptive business practice claims. Mr. Kaplan is listed as a witness on plaintiff's initial disclosure. Example 1, 2. Based on the information available to the plaintiff today, plaintiff believes that Mr. Kaplan possesses knowledge relating to UMG's use of covert tactics to promote the defamatory material. For example, plaintiff believes that Mr. Kaplan was involved in directing payments and or financial incentives from UMG to third parties involved in online botting to artificially inflate the streaming numbers of the recordings. Plaintiffs also believes Mr. Kaplan was involved in directing payments and or financial incentives from UMG to third parties for the purpose of spreading the defamatory material online, including but not limited to through third-party podcasts and streamers, in a tactic known as seeding. Wouldn't you have to know if you're getting seeded? Pause. Wouldn't you have to know you're being seeded? Pause. Seeding, for the people who don't know out there, is when companies provide product or merch or whatever that company sells or does to you for free for you to be able to promote their products. I've been seeded all kind of sneakers. I've been seeded some microphones. I've been seeded some things in exchange for promotion. So if I'm not mistaken, I would think there's an agreement at play. I could be wrong. So lawyers, please let me know. But I think you'd have to know if you're being seeded. And maybe they do have agreements with some streamers, podcasts, other parties. Not over here, though. Plaintiff believes that Mr. Kaplan engaged in his behavior through and or in connection with his relationship with Ramon Alvarez Smickle, the executive vice president and head of digital marketing of UMG's Interscope Records, as well as John Janik, the CEO of Interscope Records, Inc. Mr. Alvarez Smickle is listed as a witness on both plaintiff and UMG's initial disclosures. Examples 1 and 2. Mr. Janik is listed as a witness on plaintiff's initial disclosures. Plaintiff has repeatedly attempted to serve a subpoena. Deuces Tecum, lawyer, please let us know what that means, on Mr. Kaplan requesting 8 categories of documents, the subpoena. Example 3, the requests in the subpoena are targeted at discovering evidence of UMG's use of bots, payola, seeding, and other covert methods to promote the defamatory material. The plaintiff has made exhaustive efforts to locate and serve Mr. Kaplan without success. Why have they not been able to find him? That is my question, right? Like, people are missing. Have they been seen? Have they been heard of? Wink, wink. Is this an attempt at pretending to try to find someone? I don't know, right? I don't know. But if you can't find them, why can't we find them? That's the question. Despite repeated efforts to serve Mr. Kaplan in multiple locations over the course of more than 2 months and spending thousands of dollars, plaintiff has been unable to serve the subpoena on Mr. Kaplan, specifically beginning on or around May 30th, 2025. Plaintiff attempted to serve the subpoena on Mr. Kaplan more than a dozen times at 5 addresses, more than 12 times at 5 addresses. So are we saying 12 times at each address, or are you saying in total 12 times at these 5 addresses? Because if you try to reach a nigga 60 times and you can't get a hold of them, we might need to start looking, okay? In 2 states with assistance of 2 different firms. Plaintiff employed both Nardello and Company, an experienced private investigative firm, and Capital Process Services. So this also lends to the thought process and idea that Drake is spending a lot of money to have this done, which when we hear about the steak deal and not getting enough money and whatever the case is, a lot of people, not a lot of people, the haters or the people who aren't really just invested in knowing exactly what's going on is saying you're pocket watching. When we're not pocket watching, we're literally saying bro is spending a lot of money, and he supposedly had this $400 million deal and then another $100 million deal with Stake, if I'm not mistaken. And it seems like he's just hemorrhaging money throughout this entire case. There's no way that this case is inexpensive, to say the least. And then if you lose the case, if you're not awarded anything, then it's all for naught, right? Address 1, on May 30th and 31st, 2025, and on June 2nd and 5th, 2025, Capital Process attempted to serve Mr. Kaplan 4 times at his apartment located at, wow, they gave us the apartment, bro. 2321 Laguna Circle, apartment 301, Miami, Florida. That is insanity that all of your information is just public to everyone. That's weird, man. I hate that. Plaintiff identified this address as Mr. Kaplan's current address based on his telephone number and vehicle registration record. Wow. It almost, I don't know, man. It sounds a little intimidating. We know where you are. We know what kind of car you drive. I don't know if that's the purpose, though. I don't know if that's the purpose. I hate to think like it's this big nefarious act, but it's just so crazy that a person is literally, all of his information is out there like that. On May 30th, Capital Process knocked on the door to the apartment, but no one answered. Capital Process then spoke with the apartment leasing officer, who confirmed that Joshua Delsini lives in the apartment. How can you do that? Your apartment complex is just dropping dimes on you? How can you do that? Oh my God. An apartment 301, but his lease is over at the end of June. Okay, so he didn't renew his lease and it's already May 30th, so he probably is already gone. No, I don't know very many people that wait till the last day to get out. If you got a place and you're supposed to be out by the 1st, you might even be out the week before. You might be out the month of and just kind of go back. You know what I'm saying? So he probably already gone. Capital Process again knocked on the door to the apartment, but again, no one answered. On June 2nd, a front desk staff member informed Capital Process that Mr. Kaplan had advised apartment staff that he would move out by on May 31st. Okay, so he is still there. A month before his lease expiration. Wait. Oh, at the end of June. Okay, so it expires at the end of June. Okay. Capital Process again knocked on the door to the apartment, but no one answered. On June 5th, a leasing officer informed Capital Process that Mr. Kaplan had moved out on June 4th, 2025, and showed a photo of the empty apartment unit. According to the leasing officer, Mr. Kaplan did not provide a forwarding address. Furthermore, plaintiff found through public searches that Mr. Kaplan was sued by his landlord at address 1 on June 4th, 2025 for failure to pay rent. The June 2025 lawsuit, okay, example 7 at 1 through 5. This case was voluntarily dismissed on July 2nd, 2025 because Mr. Kaplan voluntarily vacated the address. Mr. Kaplan and his mother, Dina Kaplan, are both listed as residents of Address 1 in the lease contract filed in June 2025. Address 2. After learning that Mr. Kaplan had vacated the apartment at 2321 Laguna Circle, plaintiff identified the latest known address for Mr. Kaplan's brother, also located in Miami, Florida, and directed Capital Process to attempt to serve Mr. Kaplan at this new address. Wow. Just giving bros information left and right. On June 10th and 11th, Capital Process attempted to serve Mr. Kaplan at one, I'm not even reading it, bro. Which was where plaintiff believed Mr. Kaplan's brother was living. During the June 10th service attempt, no one answered the door and Capital Process could not locate Mr. Kaplan or his brother. Capital Process observed a woman on the balcony upstairs and called out to her, explaining the reason for coming to the address, but she went inside and did not speak with Capital Process. Capital Process returned the next day on June 11th and spoke with the leasing officer director, who informed Capital Process that Mr. Kaplan's brother had moved out in October of 2024 and did not provide a forwarding address. On June, I don't know, bro. I don't know exactly when this is taking place, but it could be a coincidence, but it seemed like they are moving like with purpose. You know what I'm saying? Like I don't know. On June 13, 2025, Capital Process attempted to serve Mr. Kaplan at 3244 North Powerline Road, Pompano Beach, Florida. God, I didn't want to read that. Plaintiff identified this address as associated with the company S1 Group LLC, which is registered under Josh Delcini. Once there, however, Capital Process, let me read this footnote. Mr. Kaplan was previously sued by the same landlord July 23rd, 2024. The July 2024 lawsuit for failure to pay rent at an address close to address that we mentioned a couple times. And Dina Kaplan was also named as a co-defendant in that lawsuit. Mr. Kaplan and Dina Kaplan were also both listed as residents on the lease contract. Okay, so let's get back to the paragraph. Once there, however, Capital Process learned that this location is associated with a company named Restoration USA, which appeared to be closed. Capital Process approached the neighboring businesses and spoke with the man in his 50s who stated that he had been at his address for 25 years and never heard of the name S1 Group LLC or Joshua Delcini. Capital Process also approached a woman in her 30s who rented a location nearby, and she also stated that she had never heard of S1 Group LLC or Joshua Delcini. How in the hell are these people aware of the ages? Are these like just guesstimates? Because it seemed like, yo, in his 50s and his 30s, how do y'all know all this? I want to know. On June 18th, 20th through 22nd, and 24th through 25th of 2025, Capital Process attempted to serve Mr. Kaplan 7 times at a home located at this address in New Jersey, and an address plaintiff believed to be associated with Mr. Kaplan's father, his entire family. They're looking for this dude and they can't find him. Plaintiff later learned that address 4 appears to be an outdated address for Mr. Kaplan's father. Address 5 on June 19th, on June 19th through the 21st and 23rd, 2025, Capital Process attempted to serve Mr. Kaplan 4 times at a home located at 311 New Jersey, an address plaintiff identified as an associated with Mr. Kaplan's mother, Dina Kaplan. No one answered the door for any of the 4 attempts, nor did Capital Process observe any activity inside the home. On August 8th, 9th, and 12th, 2025, Capital Process attempted to serve Mr. Kaplan 3 times at this address in New Jersey, an address that plaintiff recently identified as currently associated with Mr. Kaplan's father. On August 8th, Capital Process gained access to the secured building at this location. Gained access to the secure building at this address and knocked on the door of apartment unit example 4 at 10. Although Capital Process heard noise inside the residence, no one answered the door. On August 9th, Capital Process again knocked on the door and received no answer, nor was Capital Process able to to gather any information from the neighboring units. On August 12th, Capitol Process was unable to gain access to the secure building, and there were no neighbors coming or going into the building to follow behind. Additionally, plaintiff believes the email address josh@imsgroup.io is associated with Mr. Kaplan. Counsel for plaintiff sent an email there notifying Mr. Kaplan of the subpoena. Counsel for plaintiff did not receive any bounce back or response. Plaintiff also believes the phone number, is associated with Mr. Kaplan. That number is listed on the electronic signature record of the lease contract filed in June 2025 lawsuit for Mr. Kaplan. Counsel for the plaintiff called the number, but there was no answer at the voicemail recording, did not identify anyone by name. Plaintiff is not presently aware that Mr. Kaplan is represented by counsel. Plaintiff is not presently aware that Mr. Kaplan is represented by counsel, let alone counsel who would consent to service on this behalf. So they don't know if he's being represented by anybody and maybe is being, told to not. I don't think any counsel would do that. So I guess they're just saying they don't know if he's being represented currently. Plaintiff has undertaken extensive and expensive attempts to serve Mr. Kaplan through traditional means, all of which have been unsuccessful. As described above, Mr. Kaplan may be attempting to evade service, as without leaving any forwarding address, Mr. Kaplan moved out. Mr. Kaplan did not appear or otherwise respond to the June 2025 lawsuit or the July 2024 lawsuit, and he did not have any counsel of record in either of these lawsuits. On his confirmed address a month before the end of his lease, and then just days after plaintiff began attempting service on the address, see Supra at 3. Therefore, plaintiff now respectfully requests the court to permit plaintiff to serve Mr. Kaplan through alternative means, reasonably calculated to ensure that Mr. Kaplan receives actual notice of the subpoena. Specifically, plaintiff respectfully requests leave to serve Mr. Kaplan with the subpoena through each of the following methods, together the alternative means. Oh my God, here are the alternative means. By certified mail to the following 2 addresses believed to belong to Mr. Kaplan's parents. I'm not reading those addresses. By affixing the subpoena to the door at each physical address. By email, they said they've done all of this already. Or are they request leave to serve him? Okay, so they're saying not to attempt to serve, but to serve him through these means. Basically, it don't matter if we talk to you or not, we're gonna do it this way. Okay, by texting the subpoena to Mr. Kaplan's mobile phone, by calling Mr. Kaplan at the same telephone and notifying him that he has been served. The argument: the court should permit plaintiff to serve Mr. Kaplan by alternative means because service by traditional means is impracticable, including because Mr. Kaplan may be acting to evade service, and the alternative means are reasonably calculated to ensure that Mr. Kaplan receives actual notice of the subpoena. An individual located within a judicial district of the United States may be served by the following state law for serving a summons in action brought in courts of general jurisdiction in the state where the district court is located. This is a lot of... Okay, a court may direct alternative methods of service where the service by traditional means is impracticable. The meaning of impracticable depends on the facts and circumstances of a particular case. In general, plaintiff must make some showing that the other prescribed methods of service could not be made. Sirius XM Radio Inc. v. Also, they're giving you a case where they were able to do that. A plaintiff can demonstrate that the service by conventional means is impracticable by making diligent, albeit unsuccessful, efforts to obtain information regarding a defendant's current residence, business, address, or place of abode. So that's kind of why I'm thinking what I'm thinking. I don't know if it's true. Like I said, I don't know if it's nefarious or not, but I think a lot of people would look at it that way and say, why can't you reach him? Some people would say that he's hiding, and some people would say, why can't you reach him? So I guess it really just depends on what side you're on. I don't think if anybody is trying to be served and they have nothing to hide, they would probably just accept the service. But I could be wrong. maybe he don't want a part of it. Decision to allow alternative. My God, I'm reading too much. The decision to allow alternative service is committed to the sound discretion of the district court. I'm tweaking. I said alternative. Courts routinely find that the alternative service, including by email, is appropriate where the moving party provides evidence that the recipient is likely to receive the service through the alternative method. See this case. Defendant subpoena on defendant via email because the plaintiff was able to send correspondence to the defendant via email 90 days before filing the plaintiff's motion for alternative service. Okay. With respect to Rule 45 subpoenas, district courts in this court have held that in appropriate circumstances, alternative forms of service may be used as long as they are calculated to provide timely and actual notice. Granting alternative service on a non-party by way of email and text message to the email address and phone number in plaintiff's possession, as well as by mail to his last known address. So they're also just offering a bunch of different cases where this has been done. Okay. A service on Mr. Kaplan through traditional methods is impracticable. Service on Mr. Kaplan through traditional methods is impracticable. See Sirius XM Radio. Okay. As detailed above, plaintiff has attempted service through the traditional methods on Mr. Kaplan for more than 2 months at multiple addresses and in multiple states. Plaintiff has exhausted efforts to obtain information regarding Mr. Kaplan's current residence. Plaintiff is not presently aware of Mr. Kaplan being represented by counsel, let alone counsel who would consent to service on his behalf. B, service by alternative means is reason to be calculated to ensure that Mr. Kaplan receives actual notice of the subpoena. So they don't even care if you see it at this point. They're like, bro, we're just gonna put it on your desk, okay? The alternative means are reasonably calculated to ensure that Mr. Kaplan receives actual notice of subpoena. See this case, which is associated with Dina Kaplan. Plaintiff believes that Dina Kaplan is Mr. Kaplan's mother, with whom he communicates and shares contractual obligations based on the 2 publicly filed lawsuits against Mr. Kaplan. For this address, plaintiff believes that it is associated with Mr. Kaplan's father based on the shared address, the phone number, which is listed, and belonging to Mr. Kaplan on the electronic signature records of the lease contract filed in June of 2025 lawsuit. Further, plaintiff believes that the email address is associated with Mr. Kaplan, alternative service via certified mail to address 5 and 6, and using the telephone numbers that are reasonably calculated to ensure that Mr. Kaplan receives actual notice of the subpoena. Thus, plaintiff seeks the court's permission to serve Mr. Kaplan through the alternative means. These addresses, affixing it to the door, sending an email, text messaging, and by calling Mr. Kaplan. Conclusion. For the foregoing reasons, plaintiff respectfully requests that the court enter an order authorizing plaintiff to serve Mr. Kaplan with copies of subpoena through the alternative means. And that is the end. So, to me, it seems like I can't tell if the person is missing or if he's evading, right? Like, I don't know what the conversation around this is. I've definitely heard DeVille talk about Kojo, and then either not being able to find Kojo or where is Kojo. But I don't know if there's any kind of like nefarious stuff going on behind the scenes where they're just not able to find him. Is he ducking? To me, it seems like if you don't have anything to hide, maybe you would just come out and just, hey, we're going to court. But I think that's probably what that side's going to use too, right? So some of the comments were saying this. Let's actually take a look at some of these comments real quick. The document details the numerous attempts to serve Joshua Delsini, an overview of various lawsuits filed against Joshua Delsini. They playing hide and seek. Too bad the missiles detect heat. Jeez. Innocent people don't play hide and seek. First it was Kojo, now Josh Kaplan. Why are they all hiding? There's nowhere to hide. You know what I mean. Joshua Delsini right now. Everybody dodging discovery. So you could tell SMH is getting more ridiculous. Nothing to see here, just an innocent man on the run. Another one. They're all dodging. I thought they wanted him to sue and clear his name. When he said there's nowhere to hide, they knew what he meant. So basically, all these people are ignoring the notices, hiding. It's crazy that there are multiple people that they cannot find to serve a subpoena. People don't run unless they have something to hide. Why are they running? Are they scared something might happen? Everybody ain't nowhere to be found. Once is a coincidence, twice is a pattern. Everyone is getting served left and right. Why they all running? Funny how all these guys want to go into hiding now. They should hire me. I'll locate them free of charge.
Down bad, you suffering.
If they're so innocent, why are they trying to evade being served? So again, I think, you know, if you look at this in a way where you could potentially see some weird stuff going on behind the scenes. I don't know. We don't know what's going on. Or you could look at it like bro is trying to find the best way to go about accepting the subpoena and I guess the summons to court. I don't know if he has any legal representation, but lawyers, let us know in the comments, man. Hit me up on Discord. Let me know if there's any lawful reason or any reason why he would be ducking or evading, because I at some point I feel like they're either going to find him and serve him, or they just don't. And if they don't find him, then is it in Drake's favor for him not to show up? Is it in Drake's favor to make it look like he's hiding? I don't know. Y'all let me know what y'all think about this one in the comments. Definitely all over the place, but let me know how y'all feel about it. Hit that like button, subscribe to the channel. I'll see y'all in the next one. I'm out. Peace.